Good afternoon and welcome to this week's Lunch and Learn webinar. Our weekly webinars provide advice and share knowledge on key business topics. And joining me today is Catherine Hall from AB Commercial. And in today's webinar, Catherine will look at a shareholders agreement. Before we start the session, can I ask you all to use the question mark function on your screen to post any questions that you may have for Catherine, and she will do her best to answer them all at the end of the session. Okay, Catherine, over to you. Thank you very much.
Hello, as Caroline mentioned, I'm here on behalf of AB Commercial. At AB Commercial, we provide advice to businesses on a wide range of commercial legal matters. Today, I'm presenting on shareholders agreements, as they are one of the documents our clients most commonly seek advice on. You may be familiar with shareholders agreements, but I will provide some basic background for those who are not. Shareholders, who are also called members, are the owners of a company. This ownership is evidenced by shareholdings, and a shareholder has certain rights based on the number and types of shares he or she owns. In simplest terms, a shareholders agreement is a contract between the shareholders of a company in which they agree how the company will be run. A shareholders agreement is a contractual document whereby shareholders can regulate their relationship with each other. It's a private contract between the shareholders of a company, which contains the rules for running and owning the company. It is similar in intent to a partnership agreement, but it's written for a company. There is no standard form for a shareholders agreement. As such, they are very flexible and can be tailored to fit the company's individual needs. As we will discuss, shareholders agreements can accomplish many things. They can govern how a company is managed. They can protect the shareholders. They can establish fair relationships between shareholders, establish the rights and obligations of shareholders, establish procedures for the sale of shares in the company, provide direction regarding how the company will be run, provide certain protections for minority shareholders, majority shareholders, and the company, and set out how important company decisions will be made. Shareholders agreements can also include provisions requiring that further agreements will be entered into between individual shareholders and the company. For example, directors' service agreements, which are a type of employment contract, management agreements, and technology agreements, such as IT or IP transfers or license, perhaps patents, trademarks, copyright, or software agreements. You might wonder why a company needs a shareholders agreement when they already have articles of association in place. Shareholders agreements do relate closely to a company's articles of association. All companies must have articles of association, but there is no legal requirement for companies to have a shareholders agreement. Articles of association are filed at Companies House when the company is first formed, and they set out the administrative and company law procedures that affect the company, including things like the classes of shares and voting rights, dividend entitlements, and return of capital on a winding up of the company. Some issues that can be dealt with in a shareholders agreement could instead be included in the articles of association, and vice versa. Shareholders agreements work in conjunction with a company's articles of association, but putting a shareholders agreement in place can give shareholders greater protection than can be provided by the articles alone. Companies are often set up using standard articles of association, which don't include very much detail in regards to providing protective provisions for shareholders, and they don't take into account what can often be very specific commercial needs depending on the company. Further, and of much importance to some companies, articles of associations have to be filed at Companies House and are on the public record, unlike shareholders agreements, which can be kept private. A company's articles of association are governed by company law and are binding on all members of the company. They can be changed by a resolution requiring approval from 75% of the shareholders. Personal rights, such as voting rights, and provisions such as restrictive covenants are not valid if they are included in articles of association. The articles of association of a company cannot deal with matters which are personal to the members, if this could be seen as fettering the company's statutory powers. A shareholders agreement, on the other hand, is an agreement between the members of a private limited company governed by contract law, and as such, they can be very flexible in terms of the provisions included. A shareholders agreement has a number of benefits and characteristics not offered by the articles of association. As mentioned, a shareholders agreement is a private and confidential document that doesn't have to be publicly disclosed by the members. Unlike a company's articles of association, which is a public document on record at Companies House, the shareholders agreement can remain private and confidential, and it will not be open to public view, which means it is possible to keep it from being reviewed by others, such as creditors or non-member employees. Shareholders agreements can be varied upon agreement as the needs of the company change. Ordinarily, a company is subject to control in accordance with company law, which is made up of both statute and case law that determines how companies are run. However, a shareholders agreement can put into place whatever arrangements the shareholders agree upon, and the shareholders have the freedom to vary what would otherwise be the legal position. This means that members can alter or terminate the terms of their shareholders agreement by agreement, rather than having to comply with the formalities of the Companies Act. As mentioned, a shareholders agreement is a contract entered into between a company and some or all of its shareholders. It can deal with all aspects of the relationship between the parties, including personal rights and obligations of the shareholders that would be unenforceable if they were set out in the company's Articles of Association. Together with the company's Articles of Association, a shareholders agreement creates internal rules by which a company is governed. Based on the specific needs of the company, a shareholders agreement can be drafted to do the following. It can set out the shareholders' rights and obligations, regulate the sale of shares in the company, set out provisions regarding how the company will be run, provide certain protections for minority shareholders, majority shareholders, and the company, and detail how important decisions are to be made. So why might a shareholders agreement be important for your company in particular? Common situations where we see conflicts and uncertainty arise where shareholders agreements become beneficial are in cases such as the divorce of a shareholder, the death or incapacity of a shareholder, or the breakdown of a relationship among shareholders. Shareholders agreements have many ways of addressing these and other situations, and we will briefly touch on some of the options available and what they can accomplish for your company. For example, a shareholders agreement can anticipate certain problems that may arise in the event that a shareholder is going through a divorce. One such approach would be that it could set out a shareholder's spouse will not be entitled to any shares upon a divorce. It could also include other safeguarding provisions regarding the transfer of shares. A shareholders agreement could also include a clause requiring the shareholder to enter into a prenuptial agreement, incorporating the term that a new spouse would not be entitled to the shares upon a divorce. Shareholders agreements are also very important in managing and preventing disputes among shareholders. Disagreements between shareholders can involve complex matters that are not always easily resolved. If a serious dispute arises between the shareholders, it may prevent the successful management of the company, especially if constructive board meetings can't be held as a result of the dispute. In such circumstances, deadlock can occur, and in worst-case scenarios, this can result in a failure of the company and personal liabilities being incurred. A shareholders agreement can provide for a structured approach to dispute resolution, and often having a shareholders agreement in place can stop disputes before they start. Shareholders agreements can also set out procedures for a company to follow in the event that one of the shareholders dies or becomes unable to act as a shareholder. Without a shareholders agreement in place, the death of a shareholder could bring about a situation where his or her spouse or other family member could take their place. Such an occurrence may not be in the best interest of the company for obvious reasons. A shareholders agreement can prevent this by providing an option for remaining shareholders to purchase the deceased shareholder's shares. Another situation where a shareholder agreement is important is in the event where a shareholder becomes critically ill or incapacitated and can't fulfill their role as a shareholder. A shareholders agreement in this case can again set out procedures whereby the other shareholders can have an option to purchase the incapacitated member's shares. A company's shareholders agreement or articles of association can also provide that when a shareholder dies, his shares are offered to the other shareholders at a fair price. This can be beneficial for the families of the deceased or ill shareholder, in addition to the company. With the drafting of a shareholders agreement, shareholders can avoid myriad potential disputes and can put in place mechanisms for resolving disputes that do arise, along with settling up a number of protections for the company, which we will discuss. There are many circumstances where having a shareholders agreement in place will greatly benefit your company. When setting up a company with family or friends, it can be difficult or uncomfortable to contemplate what might go wrong in the future. It's very easy to assume that because you are currently getting along, excited about your new business venture, on good terms, and trust one another, you do not need to put in place something as seemingly detailed-oriented and worst-case scenario-focused as a shareholders agreement. Further, people are often concerned that requesting a shareholders agreement might give your business partners the impression that you lack trust in them or that you foresee future difficulties arising in your relationship. However, it's worth taking the precaution, as in certain circumstances, you could end up facing costly legal disputes and losses if the proper agreement is not in place. Although the company's articles of association will help to some extent, a shareholders agreement can act as a safeguard in ways the articles of association cannot. One important bonus to taking the time to enter into a shareholders agreement is that the parties will need to sit down and carefully consider and talk about important matters related to the running of the company, which they might not otherwise consider. Just taking part in these types of discussions when entering into a shareholders agreement can be very useful in that these discussions can allow the shareholders to discuss in the open many issues they may have otherwise never considered until it was too late. And these could potentially be contentious issues that could lead to serious problems in the future for the company. By discussing these issues early on, shareholders can avoid disputes in the future, and it's best to know your business partner's wishes sooner rather than later. You may be wondering when you should enter into a shareholders agreement. Putting together a shareholders agreement early on in a company's life is generally much quicker, cheaper, and easier than trying to negotiate a settlement in the event that a dispute arises and no agreement is in place to determine how such a dispute will be resolved. Founders of new companies all too often delay and put off considering the shareholders agreement. The focus early on in a company is establishing a successful business, so it's understandably common to delay it and deal with it later when they have more time and more money. The problem with delaying the shareholders agreement is that it is often forgotten and personal plans and expectations of the shareholders may begin to differ more over time. This can make it harder to hash out the terms of the shareholders agreement later on. We will look at some of the ways a shareholders agreement can make running your business easier and what it can achieve, and why it's best not to delay entering into one. Preventing or resolving disputes is just one aspect of the shareholders agreement. They can also serve many purposes in the day-to-day running of the company. They can make decision-making easier. Unless otherwise agreed to by the shareholders in a shareholders agreement, the management of the company is determined mostly by the board of directors, while only certain key decisions are resolved for the shareholders in general meetings or by written resolution. Therefore, a shareholders agreement is important to fully determine the appropriate mechanisms for important decision-making. Shareholders agreements are also vital in restricting the power of the directors where it may be necessary and in protecting shareholders against the actions of the other shareholders, whether they be minority, majority, or equal shareholders. The existence of a shareholders agreement can also be useful when a company needs to obtain finance from banks or creditors. A shareholders agreement can also evidence the stability of the business to other potential partners. As mentioned, shareholders agreements can prevent situations where one shareholder's personal circumstances can potentially have a detrimental effect on the company or other shareholder. Provisions in a shareholders agreement can safeguard each shareholder's financial interests and also the interests of the shareholders' families. So let's get a bit more into what a shareholders agreement can accomplish for your company. A company's directors are responsible for managing the business of the company, as mentioned. Directors must adhere to certain statutory duties, such as the duty to act in good faith and in the best interests of the company. But directors are not required by law to consult the shareholders about decisions that relate to the management of the company and the business. Where all the shareholders are also directors, this may not be an issue at all. However, shareholders who are not also directors may want to be consulted about or have the right to make important decisions about the company and its business. More specifically, shareholders may decide that the normal company law framework and standard articles of association should be overruled so that the agreement of all the shareholders, or a specified percentage of them, is required for certain important decisions to be made. As such, shareholders agreements are usually drafted to include provisions that set out certain decisions relating to the management of the company. that these decisions must be made by a certain percentage of shareholders. A shareholders agreement can require unanimous consent or any percentage of consent of the shareholders in relation to certain decisions. Matters commonly contemplated in such provisions are the altering of the Articles of Association, the issuing of shares, the issuing of any loan capital in the company, the changing of the name of the company, the changing of the registered office of the company, the adopting or amending of the business plan in respect of each financial year, the changing of the nature of the company's business or commencing any new business by the company, making any acquisition or disposal of a material asset, creating or granting any encumbrance over the whole or any part of the business, making any loan, granting any credit, or giving any guarantee or indemnity, granting any rights in or over intellectual property owned or used by the company, factoring or signing any of the book debts of the company, changing the accountants of the company or its financial year end, establishing or amending profit-sharing schemes, share options, or pension schemes, and dismissing any director, officer, or employee. This list is just examples of common topics for this type of provision, but this is an area where the commercial needs of the company very much come into play. Any provision relating to something of importance to the company can be added. If directors act in breach of the shareholders agreement and, for example, do something that requires unanimous consent without acquiring any consent, the act that caused the breach will still be binding on the company, but the shareholders may have a claim for damages for breach of contract against both the company and any shareholder who was involved in the breach. Having such provisions in place can help minimize all shareholders' risk because those who take action contravene to the shareholders agreement will become personally liable. Shareholders agreements can also provide important mechanisms in situations where a shareholder is leaving the company. In some companies, the shareholders may agree that all or certain shareholders will be required to earn their shares by working for the company as employees, either indefinitely or for a fixed period of time. If such an employee shareholder were to change his or her mind in regards to their involvement in the company and wish to resign, it would be unfair for them to continue to benefit from the hard work of the other shareholders by continuing to hold shares that were increasing in value. If there is no mechanism in place saying otherwise, this shareholder will be in a position where he or she may benefit unfairly from the continued success of the company due to the remaining shareholders' efforts. As such, a shareholders agreement can include terms whereby any employee shareholders who resign, or are for that matter terminated, must offer their shares for sale to the remaining shareholders. In cases where shareholders leave under bad circumstances, such as under circumstances of having committed fraud or gross negligence, a shareholders agreement can set out that the shareholder will only receive the nominal value of his or her shares. In cases where the resignation is amicable and not under such bad circumstances, the shareholders agreement can set out that the shareholder will receive the market or fair value of his or her shares. Shareholders may also want to use the shareholders agreement as a way to address the risks involved when an exiting shareholder may have had access to certain company knowledge that would put him or her in a position to be able to set up a competing business or to cause other harm to the company. To address this, a shareholders agreement can be drafted to include restrictive covenants, which attempt to restrict shareholders from setting up a competing business or attempting to attract business away from the company within certain time frames and geographical areas. As mentioned earlier, these types of restrictions cannot be enforced through the Articles of Association. Some things that shareholders may wish to restrict other shareholders from doing include the following: the setting up of a nearby competing business, the disclosure of confidential information to third parties, the poaching of key staff, and the using of the company's trading name. Without a shareholders agreement, there is little in place to prevent any of the above. It's important to note that these types of provisions require careful drafting, otherwise they may not be enforceable in court. Regardless, such provisions are certainly worth including in a shareholders agreement if they are in the best interest of the company, as at the very least, they can act as successful deterrents to exiting shareholders. Shareholders agreements can also help prevent deadlock. In situations where a company is owned in equal shares and also jointly managed by two individual shareholders, there is a risk that deadlock may arise at both board level and at shareholder level. You might think of situations where one party may want to move the business in a new direction or seek investment opportunities while the other wants to carry on business as usual and isn't open to the proposed changes. With competing ideas of what is right for the company and neither shareholder willing to compromise, no progress can be made. Deadlock situations such as these can be disruptive and damaging and can result in a failure of the business if they aren't resolved quickly. Further, unless one party has acted in breach of contract or duty, neither party may have the ability to take their case to the courts in an attempt to settle the dispute. Regardless, the parties would likely want to avoid litigation in any event. To prevent and avoid such situations entirely, shareholders' agreements can include provisions for resolving deadlock that require the parties to use reasonable efforts, such as arbitration, to resolve any deadlock. These provisions can even include timetables for resolution that set out that if the deadlock isn't resolved within the set timetable, then a mechanism whereby the shares are sold by one party to the other can come into effect. Shareholders' agreement can also do much in the way of protecting the rights of minority shareholders and the value of their shareholdings. As mentioned, company law rules generally provide that the will of the holders of a majority of the voting rights will prevail. So, without a shareholders' agreement in place, a minority shareholder, which is a shareholder who owns less than 50% of the shares, has little control in regards to how the company is run. A minority shareholder only has limited power to block shareholder decisions. Shareholders in some companies will want to vary these usual rules with shareholders' agreements because without a shareholders' agreement in place, majority shareholders may be able to force through issues that are against the interests of the minority shareholders. Once a shareholders' agreement has been executed, it can only be amended with the agreement of all the shareholders. Even if the company's articles of association include provisions intended to protect minority shareholders, the article of association can still be changed by special resolution, which means by a decision of 75% of the shareholders. For minority shareholders, having a shareholders' agreement in place that includes requirements that all shareholders must approve certain decisions ensures that the minority shareholders have input in important company decisions, such as the ones that I outlined previously. Of course, it should be kept in mind that if the shareholders' agreement requires all decision-making to be anonymous, this would have the potential to thwart the effective running of the business. It's important to take the commercial needs of the company and its day-to-day running into consideration when drafting these terms. Minority shareholders may also want to think about the importance of provisions regarding share sales. For example, a minority shareholder may want a provision setting out that if a majority shareholder is going to sell his shares, then the same offer to buy must be extended to the minority shareholders. This is often called a tag-along provision, which forces the purchaser of the majority of the company's shares to also purchase the minority shareholder's shares. A provision such as this can work to ensure that the minority shareholder will receive the same return on their investment as the other shareholders. Majority shareholders also have much to gain from having a shareholders' agreement in place. Shareholders may have differing opinions regarding the value of their business and when to sell. Even if they have agreed to sell, they may still find themselves in disagreement over the terms or exact timing of a proposed sell. To address this, shareholders' agreements commonly include what are called drag-along rights. These drag-along rights allow the majority shareholders to force minority shareholders to sell their shares in the company in a situation where the majority shareholder has an offer to purchase their shares which they wish to accept. This allows majority shareholders to realize their investment at a time and price of their choosing. Drag-along rights favor the majority shareholder by enabling the majority shareholder to compel the other shareholders to sell their shares if the majority shareholder has agreed terms for the sale of the company to a buyer. The name comes from the idea that a drag-along provision allows the majority shareholder to drag the other shareholders along in the sale. These provisions make sense because potential buyers will rarely agree to a minority shareholder retaining a minority share. The provisions will set out the minority shareholder can't be forced to sell unless the price and the terms upon which the majority shareholder has negotiated the sale are also extended to the minority shareholder. Drag along also protects the majority shareholder in that it prevents the majority shareholder from being locked in. These types of provisions must be considered carefully. Shareholders must consider whether they are willing to be forced to sell and whether the minority shareholders are happy to rely on the judgment of the majority shareholder, among other things. Drag and tag provisions can both protect the value of a company's shares by avoiding the shares being locked in. A minority shareholding is difficult to sell and is such at risk of a buyer setting a price with an inaccurate relationship in regard to the company as a whole. As such, a provision ensuring his or her shares can form part of a larger number of shares in order to keep the price up can be a very important provision for a minority shareholder to consider. There are other protections for majority shareholders, which can be included in a shareholders agreement. Restrictive covenants placing limits on the sharing of confidential information, the setting up of a rival business, and poaching of clients. These were mentioned earlier and are further protections for majority shareholders that can be incorporated into a shareholders agreement. Shareholders agreements can also set out restrictions on share transfers, which prevent a shareholder from transferring shares to anyone of their choosing. This is generally handled with preemption rights, whereby a shareholder who wishes to sell his or her shares must first offer the shares up for sale to the other shareholders and then to the company before they can be sold to a third-party buyer. Without a shareholders agreement in place stating otherwise, a shareholder is able to sell their shares to anyone. This means that even in contentious situations, such as where there is an ongoing dispute, a shareholder could sell his or her shares to a competitor. Or, if a shareholder found him or herself in financial difficulty, they may decide to sell their shares to the highest bidder. Clearly, either of these situations are likely not in the best interest of the company. This is where the preemption provisions come into play, allowing a right of first refusal to the continuing shareholders. What this means is that existing shareholders will have the right to purchase shares before they can be sold to anyone else. This type of sale could be governed by a set formula for valuing the shares or by matching the price of an outside bidder. Shareholders agreements also typically include dividends policies, which can be very standard or very complex based on the needs of the company. If a company has made enough profit, it can pay dividends to its shareholders. In addition to whether it has made profit which is entitled to distribute as dividends, payments of dividends also depend on whether the directors have agreed that a dividend should be paid. As such, the payment of a dividend to a shareholder is not guaranteed. A shareholder agreement might contain a dividend policy that sets out guidelines for when and how dividends are to be paid, such as an agreement regarding when dividends will be paid and how the amount of the dividends will be calculated. It's important to note that there are tax considerations when it comes to dividends. A stated dividend policy may affect the value of the company's shares for tax purposes. Also, some of the shareholders may agree to waive their receipt of dividends for a certain period of time, or even permanently. Such provisions may also have tax implications, so this would be something to consider when drafting a dividends policy. Such considerations should always be discussed with the company's accountant. Another important area shareholders agreements can come into play is establishing mechanisms for valuing shares. Many shareholders' disputes tend to arise over the issue of how to value the company's shares. Valuation of shares comes up in situations where a transfer or disposal of shares is occurring, which we discussed previously. Because of this, an important component of a shareholders agreement can be having in place an agreed mechanism for valuing shares. Again, such a valuation method should be discussed with the company's accountant. Shareholders agreements and accompanying documents can also put in place terms regarding liability of shareholders in different circumstances. An example of this is relevant when personal guarantees are in place. As those who have set up a new business will know, it's very common for new companies in particular to face lenders or creditors who require personal guarantees from some or all of the shareholders. When this occurs, the shareholders may want to spread their liability under such guarantees between all the shareholders. Such an agreement in relation to personal guarantees can be included in the shareholders agreement. As mentioned briefly earlier, a shareholders agreement can also put in place the procedures for circumstances where a shareholder can be forced to exit. For example, in cases of fraud, dishonesty, gross negligence, material breach of the shareholders agreement, and bankruptcy. the consequences of not having previously agreed provisions in place to cover such scenarios can have very serious implications for the company. We've discussed the agreements that can be put in place within a shareholders agreement, and it's important to note how such agreements are forced. As mentioned earlier, a shareholders agreement is a contract between the shareholders, and any action taken in breach of the shareholders agreement may lead to a claim for damages, but will not generally affect the validity of the act. This is a reflection of public policy which prioritizes a finding in favor of the validity of acts of a company. If the company's articles also restrict a shareholder's ability to transfer their shares, the rights of the other shareholders will be stronger because a company is not permitted to act outside the provisions of its articles. Therefore, the same transfer of shares which is not permitted by the company's articles will often be legally invalid. As such, it's a good idea for a company to adopt new articles of association when a shareholders agreement is put in place so that the articles are consistent with the terms of the shareholders agreement. I'll wrap things up now, but as these examples show, shareholders agreements offer invaluable protections for companies and shareholders. It's a good idea to consult an accountant along with your solicitor so you can get the best advice on drafting an agreement that is best suited to your company and meets your needs. The flexibility of a shareholders agreement makes them ideal for setting out the individual requirements of your company that will help it run smoothly and in line with your vision for the company. And taking the time to invest in a good agreement now can save money and avoid conflict in the future. If anyone has any questions, I'll be happy to do my best at answering them now. I've also provided my email address on the screen, so if you have any questions you'd like to discuss in a bit more confidential way, then that would be great too.
Great, thank you so much, Catherine. That was a great session. We do have a couple of questions for you. As you've said, a shareholder agreement should be put in place when you set up your business. But Lucy has asked, should we put a shareholder agreement in place now as we are nearly 18 months, 2 years old?
Yeah, it's never too late to set one up. It's a great thing to contact your solicitor about and discuss, I guess, where you stand in your company, what's happening, and how one might benefit you. It's obviously a personal decision, but I mean, as I went through, there's a lot of benefits, and there's certainly no reason to put it off just because you didn't do it right away.
Okay, thank you. Another question. What is the ballpark figure for the cost of putting together a shareholder agreement for an SME?
At AB Commercial, we generally quote starting at around £450 for plus VAT. It's a fixed fee, but that's a very standard agreement, so it would just have to be something we would discuss on an individual basis.
Okay, thank you. Another question. How often should my shareholders agreement be updated?
It really just depends on your company and the changes it's going through. When you're bringing on new shareholders or looking at new financing, it's always a good idea to look into it. I think usually if you're doing anything with your accountant or solicitor, you might want to check with them and ask how it might affect your shareholders agreement.
Okay, thank you. And how can a shareholders agreement protect me and my company?
I think I went over that in a lot of different ways, and there's always ways I'm sure that I didn't include, because shareholders agreements, really that's what's great about them. Since they're a contract, they're very flexible and you can sort of bend them to your needs. But as I mentioned, it does just kind of set out ways in which you can prevent disputes from occurring in the future because you have sat down and had that conversation about how decisions will be made and kind of set out what you'll do in the worst case scenarios, which hopefully you'll never face. But if you do face them, it's great to have a document in place and great to have already had all those discussions so there's nothing hidden or unexpected that crops up.
Okay, thank you again, Catherine, for joining us this afternoon. As Catherine said, her contact details are still on the screen now, so if you do have any other questions, then you can email her direct, and I'm sure she'll do her best to answer them as quickly as she can. I will, of course, send out a copy of today's presentation to you all today. And just lastly, Catherine and I would like to thank you for joining us, and we hope you have a great afternoon.
Thank you.